Warahmatullahi Wabarakatuh. We are from Group 9 and our topic for our assignment is Biotechnology Patents, a discussion of its subject matter in Malaysia and the UK, in the United Kingdom. So my name is Amira Shakira binti Muhammad Nordin. My matric number is 051274. My group mate is Nurina Arwa binti Luqman Hakim and Sneha Nerabi Chanda. Next. So I will proceed with the introduction. Patent is one of the exclusive right under the intellectual property which is issued to an invention, a product, or a process which particularly will give rise to a new way of doing something or provides a new technical solution to a problem. So inventors will have the right to exclude others from illegally exploiting his inventions for the purpose of commercial or industrial. The duration of patent is limited to 20 years, and it was stated by Abraham Lincoln that the patents were intended to encourage entrepreneurship and industrial development by introducing incentive fuel to the genius fire. However, on the other hand, patents law were frequently been accused of promoting monopolies, R&D corporatization, in which the rate and direction of innovations are largely driven by commercial motives without much genius fire. Next. Biotechnology is defined as a wide range of biological processes, organism, or system to generate products targeted at enhancing the quality of life of humans. Technical developments in recent years have made it possible for the industry to develop into the major player it is today, enriching all facets of life. It is also involves scientific and industrial studies focused on understanding and modifying molecular level living or biologically active material, often involving DNA techniques, genetic information analysis, human insulins, interference vaccines, and treatment for a host of human affliction such as septic shock, anemia, diabetes, AIDS, cancer, hepatitis, and also heart attack. It has been argued that biotechnology can be safe to say as a set of technologies applicable to a spectrum of industries instead of known as an industry. As a great invention, biotechnology needs to be protected for a reason to provide return on investment in research and development made by the inventor by granting monopoly rights for a certain period of time to their owners. It is important to be protected as biotechnology involves life forms. Exclusive patent protection can be issued only if an acceptable degree of concrete and functional usage of the biotechnological technology is disclosed in the patent application with regard to the commercial applicability and also adequacy of disclosure. Biotechnology patenting has been widely criticized in the global sense, aside from being struck by legal and ethical problems, on the grounds of mere changes of substances existing in nature and their subsequent alteration by human intervention. Hence, this writing will discuss further about the applicability of biotechnology patenting between two countries which are in the United Kingdom and also in Malaysia. Next, I'll pass to Nurina.
Okay. Hi, I am Nurina. So I will be presenting on the biotechnology patent in UK. Main law which governs the patents in the United Kingdom is the Patents Act 1977. As the UK was a member of the European Union, EU, the UK was also a part of the EU Patent Convention, namely the European Patent Convention (EPC). Even though UK has left the EU membership on 31st January 2020, the status of UK in EPC does not change anything, as EPC is an independent organization from EU. The patentability of the invention can be seen under Article 52 of EPC, where patentable inventions are defined. Next. Okay. The patentability which applies for biotechnology is different from other technology. Biotechnology patentability is not similar to other fields of technology as it deals with a lot of specificities. Since biotechnology deals with biological materials, it was contended by some people that biotechnology inventions are just some trivial findings which are not qualified to be patented. And the other says that biotechnology inventions are artificial, which are developed by a human being. Next. So, biotechnology patentability subject matter in UK. Okay, not all biotechnology is patentable as it must comply with the requirement provided under the UK Patents Act 1977, EPC, and also the Biotech Directive. Since the UK is still part of the EPC and also Biotech Directive, the UK Patents Act 1977 are directly affected by those two conventions. According to EU Directive, isolated biological material, even it is previously in nature, is considered as the patentable subject matter. So, examples of the isolated biological materials are nucleic acid molecules or DNA, proteins, and cells. This is also includes plants or animals, if not confined to a particular plant or animal variety. For example, transgenic plants or animals. Next, wait, okay. Other than that, microbiological process and products are also patentable under this provision. This includes the methods and uses of the biotech-related products. For example, producing a protein, PCR, in vitro diagnosis, making foods, and medicines. It is provided that only the above subject matters are patentable, as Article 53 of EPC provides for the exceptions to patentability. This is because the subject matters under the said article are not qualified to be patented as it is contrary to the public policy and involve moral issues. Furthermore, this provision is also stated in Schedule A2 of the Patents Act 1977, which does not include the plants and animals varieties to be patented. Okay, next. So, due to moral issues, the exclusion of patentability includes the process for cloning humans and modifying the germline genetic identity of humans, using human embryos for commercial or industrial purposes, and processes for modifying the genetic identity of animals if their production causes suffering without some substantial benefits. This can be seen in the case of International Stem Cell Corporation (BL). The court held that the claims made by the claimant for the method of producing stem cell line methods of producing synthetic harness and clean tissues, which constitutes the commercial use of human embryo, is considered as unpatentability subject matter under Schedule A2 of the Patents Act 1977. Next,
Okay. For
I will
biotechnology
pass the
patent,
next presentation to Sneha.
okay. Biotechnology patent subject matter to Malaysia. Malaysia's patent law, similar to those of other jurisdictions, excludes certain subject matter from patent protection. Such subject matter is defined in accordance with Section 13, Clause 1 of the Malaysian Patent Act. This non-patentable topic in Malaysia impacts the life science industry. Some of the related examples are discoveries and scientific theories, varieties of plants and animals, or essentially biological processes for the production of plants or animals, methods for treatments of human or animal body by surgery or therapy, and diagnostic methods for humans. Next, the Malaysian IP Office (MyIPO) has significant impact on the understanding and implementation of Section 13 Clause 1 Clause A and 13 Clause 1 Clause B of the European Patent Convention (EPC) to year 2000 and the European Guideline for Legal Defense of Biotechnology Inventions. According to Section 13 Clause 1 Sub A, it applies to discoveries, while Malaysian patent law does not offer protection for the discoveries of new species. It is possible to protect the composition or methodology of the extract derived from the new species if it meets the criteria for patentability. In Section 13 Clause 1 Sub B, specifies that flora or fauna types, or basically biological processes for their development rather than human-made living microorganisms, as well as the microbiological processes and products of those processes cannot be patented. The provisions of EPC year 2000 were adopted by MyIPO in understanding and in incorporating the provisions of Article 13 Clause 1 Sub B for care and diagnostic methods which would be useful for medicinal and medical use. Next, Section 13 Clause 1 Sub D specifies that all non-therapeutic treatment methods are patentable, whereas surgical and therapeutic treatment methods are excluded from the protection. Pursuant to the provisions of the European Patent Convention, MyIPO does not exclude from the patentable subject matter devices used in treatment or diagnosis, which means that surgical, therapeutic, or diagnostic equipment may be asserted. Next. I'll pass this to Amira.
Okay, for the conclusion, the issue of patentability in biotechnology is handled differently by respective countries, including Malaysia and also United Kingdom. The subject matter for both countries on biotechnology patentability must be based on the ground of its objective and for the sake of public interest. Although it is possible to apply for a patent in any scientific invention, patentability of biological materials is always a subject of debate. Some claim that biological materials are mere discoveries and thus not patentable. Others contend that such biological materials are thus patentable man-made creations. As for United Kingdom, the patentability in biotechnology is not applicable for all types of biotechnology invention. This is mentioned under the UK Patents Act 1977, EPC and Biotech Directive, where there are some requirements which need to be fulfilled in order for the biotechnology invention can be patented. This is also happened in Malaysia, where not every inventions of biotechnology can be patented. Their protections of new inventions or species such as plants and animals cannot be patented under the Malaysian patent law. However, the protection is offered for its composition or methodology in deriving the new species. So that is all from us. Thank you.